Hi, Hugh Lockdale here from Oak Park Chartered Accountants. If you recognise that graphic, whoever opens the mail in your pharmacy probably handed you a postcard recently. It'll have a QR code on the back so that you can easily access, or anyone else you know buying a pharmacy, this series of videos for your upcoming pharmacy purchase. Okay, well this is the third in our 4-part video series, Buying a Pharmacy. You've probably already watched videos 1 and 2, and I hope you're finding them useful. Today I'm covering some legal issues, in particular structure, your sale and purchase agreement, employment agreements, leases and trusts, and I'll touch on 1 or 2 other issues. So structure firstly. Your choice of legal structure to own your pharmacy is pretty easy. The sole trader and partnership and trust and joint venture models are not going to give you the limited liability you need, so a company is the simplest and best structure for owning a pharmacy. And 100% of pharmacies in New Zealand, as far as I'm aware, operate in a company structure. So structure choice is an easy one, but you should still get advice. Now the word limited at the end of a company name refers to limited liability. It means that the financial liability of shareholders is limited to the net assets of the company. So if the company goes under, a bank or other creditor cannot look through the company to access the shareholders' personal assets to satisfy that debt. An exception is that if you have granted your bank a personal guarantee for their lending, they effectively are granted an exemption from limited liability for their loan obligation. Similarly, directors are only personally financially exposed to the creditors of the company if they breach one of their legal duties. For example, they trade while the company's insolvent, or they trade recklessly. Another exposure for directors is fines under the Health and Safety and Employment Act, which can be levied personally on directors, and the maximum fine is $600,000. That's not to mention a possible prison term. It's illegal to insure against health and safety fines. In both cases, you might like to consider a trust for your personal assets, and I'll talk about that later. Now you can call your company whatever you like. The norm is to call it the name of the pharmacy with perhaps a date on the end of it, like say Petone Pharmacy 2021 Limited. If you want to have a brand name for your business, perhaps you're going to call it, I don't know, Pills by Drone. Calling your company Pills by Drone Limited will not protect that brand name, Pills by Drone, from others using it, only from others having a company name similar to it. To protect a brand name, you need to talk to your lawyer about registering a trademark. Shareholding. Now you'll know from pharmacy school that the Medicines Act requires at least 51% of the shares in a pharmacy-owning company to be held by a registered pharmacist or pharmacists. Now, commonly the other 49% is owned by either the pharmacist again, so they own the whole lot, by a spouse of the pharmacist, or by a family trust. Now, if the joint family home is securing the lending for the pharmacy purchase, it makes sense for the spouse to own the remaining 49% of the shares, but it's up to you both. Now, directors. Directors have significant legal responsibilities and duties to shareholders, to creditors, and for fulfilling various legal responsibilities under the Companies Act and various acts. So while there is some reason for a spouse, because they own 49% of the shares in the company, to have a seat on the board as director, usual advice is only to be a director if you have regular involvement in and knowledge of the operation and finances of the company. Some education on your basic legal responsibilities as a director is highly advisable. Your lawyer will likely have a booklet on it. Have a read. At Oak Park, we include it in our new and business training sessions, for which most of our new pharmacy owner clients choose to receive from us. Now, a company costs little to set up. We charge $350 plus GST, and that includes $120 in company's office fees. Don't set it up yourself. I've seen people think they can do that and really mess it up. It's not costly. An accountant can sort out the IRN number application and GST registration at the same time as the incorporation, which is very efficient. I estimate that as much as half of pharmacies in New Zealand use the business premises as the registered office of the company. Now that is not a good idea, and hopefully your accountant will tell you why. If they don't, without you asking, you probably have chosen the wrong accountant. There are numerous records the company's office requires that are kept at the registered office of the company. Failure to do that constitutes an offence by all of the directors in many cases. So ask your accountant to make their office the registered office of the company. Most don't charge for that service or charge a small nominal fee. Now, generally with setting up of your company structure, keep it simple is my recommendation. Some businesses get a bit fancy and set their company up with A and B shares, where the A class, say, have voting rights and the B class of shares have dividend rights. Now, if you have another party helping fund the purchase of your business, then this could be helpful. Just keep it as simple as necessary for your purposes. Have a chat to your lawyer about that. All right, that covers the setting up of your company. I mentioned trusts earlier. If you own your own home, you should consider parking it in a trust. While a company structure gives you limited liability protection, as I explained, there are situations where a director can be personally liable for actions taken as a director or neglected as a director. Now, as a pharmacist, theoretically, you can kill someone through something going badly wrong in script preparation, or a staff member of yours could. Now, you'll have professional indemnity insurance, for example, through PDA, to cover for this sort of event, but it's comforting to know while you trade on and you'll get really busy, that your family home is properly insulated from business risk. And just by the by, your partner will sleep better at night knowing that their family home also is not at risk from something happening in your business. So putting your home into a trust is something you can do down the track, but I do recommend you have the conversation with your lawyer anyway, so you understand why you might want to do that, and to assess whether doing it now or doing it later is the best thing for you. Okay, trusts well and truly fall into the lawyer's expertise, as do most of what I'm saying today. So I've just touched on trusts very briefly here. There is a lot more you need to understand, so talk to your lawyer about that. So I've talked about setting up your company and briefly about trusts. Now, your sale and purchase agreement. As I said in my last video, pharmacy purchases are not very different legally from the purchase of any retail business. I also mentioned in my last video the reasons to favour a 31 March balance date, settlement date rather, that you should plan your license and contract applications well in advance of whatever settlement date will be, and how the pricing and the split of the components of a pharmacy work. One of two things I want to mention here regarding the sale and purchase agreement is stock take. Now, as specified in the agreement, this happens on settlement day, usually after the pharmacies shut the doors for that day. All pharmacies are not equal when it comes to stock recording. Some do rolling stock takes and their stock records are pretty accurate. I have seen pharmacies, particularly with older vendors, who have never done rolling stock takes or even an annual stock take to check their records are right. So they just take and trust whatever's on Tonique or RX1 And that is what the figure that might have ended up in your sale and purchase agreement. So on settlement date, you need to attend and do a stock take with the vendor, make sure dead stock is not counted, and confirm the true stock value. Hopefully similar to what is in the stock sheets and was included in the agreement. Any shortfall over the estimated value is refunded to you, and any excess, you have the option of accepting that extra stock, or the vendor removes it from the shop. By the way, stock is always GST exclusive and at cost. Second thing is a smart lawyer I came across recently, as a matter of practice, made a certain provision regarding purchase price, which ended up being quite a lot of value to theirs and my client, the purchaser. It's completely legit, it's nothing shady at all, but I've advised on many pharmacy purchases, and this adjustment is not well known to lawyers, which means the vendor's lawyer and accountant probably won't pick it up. I will say that in this case, the purchaser gained quite nicely from the adjustment. I won't say in this video what that adjustment is, but if you want me to look after your purchase, I'm happy then to tell your solicitor about it. Okay, employment agreements. Now, sacking people, as you will find out, unfortunately, one day is hard. Legally, it is hard to get rid of unsatisfactory staff. There's a strict process you must follow, or you could end up on the wrong side of an unjustified dismissal claim. Not pleasant. So you have one golden opportunity at the business purchase to remove them very easily by just not offering them an employment agreement. If you've worked in the business, you'll know who those people are. If you haven't, you need to find out. Obviously, how you do this is important. You need to liaise with the vendor and do it tactfully. Otherwise, it'll get messy and you could spook the other staff. But if you should do it, make sure you do it. You'll be glad you did further down the track, when you have to deal with them later and go through the drama and follow all that due process and learn the hard way. You can do without that task as a new business owner. All right, the lease. Now, your location, especially if you're next to a medical centre, is very, very important, as I'm sure you'll understand. Therefore, your lease is very important to secure. Your new landlord must approve you. You will need to personally guarantee your lease, probably. Personal guarantees are a pain, but your landlord will almost certainly require it. The reason is, and you need to understand that, is that a lease is not a month-to-month obligation, even though it seems like that because you pay the rent every month. A lease is a legal commitment to occupy and pay for the premises till the next renewal date. So that is a multi-year financial obligation to pay rent regardless of whether you stay in business or moved. Obviously you wouldn't move until the lease is over, but you have to pay it through to the end of the lease term. Also on the lease, the vendor may assign their lease to you, meaning the terms continue as is and they remain guarantors until the next renewal, or you negotiate a brand new lease. I've seen both done happily many times. A new lease is cleaner. However, it's the preference of most lawyers I deal with these days. One problem with old leases assigned is pre-2011, they didn't have the Christchurch clause in them that entitled tenants not to have to pay rent if they couldn't get access to the premises. So that's just another reason to have a brand new lease. You need to appraise the suitability of the premises you are leasing. Pretty standard, but some older pharmacy premises don't have a consulting room and they don't have room for one. I've seen some very tight shops, generally older pharmacy stores. So you may want a shorter term lease in instances like this to give you the flexibility to find better premises in the short to medium term. You don't want to be without a consulting room as a pharmacy these days. Now this purchase is a big new commitment and there's a lot of new debt. Make sure you have your lawyer review your will. It's prudent to see a broker too about increasing your life insurance, at least until your debt is repaid. Relationship property advice. Now, sadly not all relationships are forever, but paying out half of your assets to an entitled ex-partner is. So you may want to ask your solicitor to give you relationship property advice. Okay, I've come to the end of the video on legal matters. There's a bunch of laws that will affect you as a pharmacist and a retailer. The Medicines Act, the Consumer Guarantees Act, the Fair Trading Act, the Health and Safety and Employment Act, the Employment Relations Act, the Holidays Act, the Privacy Act, and I'm barely getting started. There are a few things you must know at the start, and I've covered some of those. Some of those you would have learned in pharmacy school. But there's no way around it. You are going to have to learn about these as you go. And as I said in my first video, if you choose a lawyer who's helpful, accessible, and doesn't mind answering questions, it'll be a real help to you along the line. All right, that's all for this, the third video in our 4-part video series on buying a pharmacy. Tune in for the 4th video where I'll give you some hints on the first year or two in your business. So my contacts are coming up shortly. Give me a ring or an email if you've got any questions. Hugh Lockdell from Oak Park Chartered Accountants signing off.